And he was present in court on November 12th when the trial date and time was scheduled. It was scheduled for December 10th, 2019 at 9 a.m. And even though this was a very important matter to him, he failed to show. He came to court late that day, and the judge had already defaulted him. He would have had an opportunity in court at that trial to raise whatever constitutional arguments he wanted to raise regarding the validity of the ordinance. And in spite of that, for whatever reason, he didn't show. The judge defaulted him and found him guilty. Mr. Sprague, as he mentioned, filed a motion to reopen the case, and the judge issued a written decision refusing to reopen the case. And I just want to read a couple of excerpts from that decision. Court trial is scheduled on this matter for December 10th, 2019 at 9 a.m. The defendant was present in court on November 12th, 2019 when the trial date and time was scheduled. Assistant City Attorney showed up on time for the court trial along with two witnesses, City Police Chief Eric Wohler, City Building Inspector Roger Muslaw. The defendant did not appear. The court waited until approximately 9:07 a.m. and then granted the city's motion for default judgment before adjourning at approximately 9:15 a.m. The judge says a reasonably prudent person would have noted the correct time for the trial and shown up on time. Mr. Sprague did not do that. He does not claim his incorrect assumption that the trial was scheduled for 10 a.m. when he was told in court that it was 9 a.m. was anything other than neglectful carelessness or inattentiveness. He did promptly act to attempt to remedy the default judgment by immediately moving to reopen it. Goes on to say, Mr. Sprague has not submitted any evidence indicating that he has a meritorious defense or that he would likely have prevailed had this matter been tried at the time scheduled. Therefore, there is no demonstration of any possible miscarriage of justice if the default judgment is allowed to stand. So, as I mentioned, Mr. Sprague could have come to court on that day and raised whatever constitutional arguments he wanted to raise. And the vehicles are still at his residence. And this was part of one of the directives from the city over the course of the council over the last summer and into this summer in terms of removal of junk vehicles. And there were many junk vehicles that people agreed to remove on their own. So there was a lot of progress made in that regard, and this is just a continuation of that effort.
What work did you do to make sure that they were vehicles compared to an automobile?
Mr. Sprague, I didn't interrupt you while you were speaking, so I'd appreciate it if you would not.
You did twice.
Me. So,
it's a valid question.
Our plan is to continue with the prosecution of this matter. Mr. Sprague is free to raise any constitutional objections with the judge in court, and I invite him to do so. And the judge last time apparently found no issues with the constitutionality of our ordinance and proceeded to find him guilty. And so my plan is to continue with the prosecution of the matter, and he can raise his constitutional arguments in court, and we'll let the judge decide.
So those vehicles, could they be removed?
They could, if the judge finds that he is guilty.
What's going to happen when they have to remove me from an automobile that they're trying to steal on an unconstitutional ordinance because I don't want to do it and they can't get a warrant?
And one of the reasons why I want to take this back to court is to allow Mr. Sprague the opportunity to raise his constitutional.
I would like to save the resources. They're not his money. He doesn't care about wasting people's money.
No. He's given you an opportunity.
Yeah, he hasn't though. He's told me I'm wrong when he's wrong. Are they automobiles? Ask him what's the difference between a vehicle and an automobile.
So
I've heard a vehicle out of his mouth twice.
I think, I think you have a flavor for what transpired that day at my office. In 25 years.
I don't put up with it being wrong. If he doesn't know the difference between a vehicle and an automobile and he's going to still claim they're vehicles, that's the core issue.
In 25 years,
This is a legal matter. This is ridiculous.
there have been 2 occasions where I've asked people
Can
to
you be
leave
right?
my office. And Mr. Sprague was one of the 2 in 25 years. His conduct was horrible. My secretaries were appalled by his language and his conduct. And I'm not going to put up with that in our office.
Shouldn't have to.
I shouldn't have to put up with an attorney that can't tell the difference between a vehicle and an automobile in a
As
legal
I said,
sense.
I'm going to give him an
No.
opportunity in
This is
court
ridiculous.
to
He
raise
can't tell
his
you a difference.
constitutional arguments. It's for the judge to
He's
determine
costing the city money because he doesn't know the difference between a vehicle and an automobile.
There are
Why do we
people-
need to go to court? None of them were vehicles that he stole. They were all vehicles. They were automobiles.
There are certainly plenty of citizens
That
in
wouldn't fight you
Antigo-
because of your attitude.
in Antigo who have a different personality than Mr. Sprague.
And you
who do
railroaded
not
them.
want junk vehicles in town. They do not
They're
want
automobiles.
junk piled up in their neighborhood. And those people are absolutely upset over that type of thing. So
Yeah,
they
well,
have a
get used to
different
my
opinion
property.
than Mr. Sprague, but apparently his opinion is the only one that matters.
I think taking it back to court, letting him express his opinion, let the court decide, go from there.
You're fine with a $10,000 lawsuit going out to me over automobiles because an attorney can't tell the difference between an
Doesn't matter,
automobile and
you
a
can do what you
vehicle?
want, but
I would like to be civil and reasonable, but you people are making it very hard to be civil or reasonable. But it's not, it's simple. It is in the court system and it's a misapplication of what is there. He can ask him what a vehicle and an automobile is. He still has not done his diligence.
Make your
He is
arguments
being
to the judge
deceitful
about the
here.
constitutionality.
Why are you being deceitful, sir? And what is so hard about admitting that a vehicle is different than an automobile and you are willfully committing treason by willfully stealing by the misapplication of an ordinance? Yep, I'm going to be here in the meeting every time, and it's going to be like this every time because he can't answer the difference between a vehicle and an automobile. I bet anyone $10, and I will apologize if you will tell me I'm wrong that it's a vehicle or an automobile. I need to speak with you out here for the public records request. Huh? I'm not wasting my time. I'd like to finish my business that matters. Okay, and then Barsky last night, I need that evidence preserved because I'm gonna do a FOIA request for all that. He threatened me with arrest. He thought I'm not sure if you got a chance about my charges yet, but did you look at them or no? And you're still pursuing them? How long is it gonna be?
5 minutes if you don't want to talk.
I'll wait out here a little.